Good morning, everyone. I want to thank you for being patient so we could have the captioning available for our public members in New York City. So we'll get started. I know we're a little late. Can we start with the introduction, and how about we go from New York City, then we'll do Buffalo, then we'll do Albany. So if we could start in New York City, please.
Can you hear us?
Yes.
Okay. Anna Kim, otolaryngologist, board member.
Oh, everybody, even the public. Sorry. Janice Schachter, chair of the Hearing Access Program.
Jerry Bergman with the Hearing Loss Association.
Benjamin Platt with the Hearing Loss Association.
Jane Seifert with the Hearing Loss Association.
Tony Iacolucci, Hearing Loss Association of America.
Holly Cohen, Hearing Loss Association.
Freddie Jarmel, Clinic Director for Audiology at Montclair State University.
Barbara Kruger, audiologist, past board member and consulting audiologist.
Anthony Macera, audiologist and board member.
Jack Bolello, Chief Investigator, Division of Licensing Services.
Department of State.
Is that it for New York?
Yes.
Yes.
Okay. Buffalo?
Ann Orsini, audiologist, board member.
Ron Schwartz, licensing.
Okay, we'll start at Albany. I guess I'll start. Keith Simon, Department of State. While we get started in Albany, can I remind people to use the microphones? I know, just pass it around. We only have 2 of them, so.
Whitney Clark, Department of State.
Linda Cleary, Department of State.
Mike Romanov, Department of State.
Melanie Grossman, Department of State.
Judy Blau, Department of State.
I'm Jim Hines, representing the Commissioner of Education.
John Kennel, Dispensary, New York City.
Sean Newlands, otolaryngologist, board member.
Ed Elio, audiologist, board member, Kingston, New York.
Board member, consumer who wears a hearing aids.
Carol Fansler, Department of State.
Mark Mastribuno, Department of State.
Donna Zoller, Department of State.
Okay. Before we start with the agenda, just a couple of things that I usually go over at the very beginning, just to to allow the meeting to go on properly for us. Like I said before, remind everybody in Albany to speak one at a time. Same with the regional offices in New York and Buffalo. My best advice for the regional offices is try to keep your end muted unless somebody is speaking. And that helps because the microphones are voice activated. So every time people flip papers, the microphone wants to start, and it starts, stops, and so it's better if it's muted unless you want to speak. And if you want to speak, remember to hit the button again. If people would do that, that would be a big help. As we make our way down the agenda, when we get to the public comment period, I do want to remind both the board members and the public that it's a public comment period. It's mostly the public who make comments in front of us. It's not really a back and forth discussion thing. So we'll try to keep it that way. Sometimes it doesn't go that way. And I will just remind the people, everybody is welcome to speak. We just ask that you kind of keep it brief. Try to limit it to 5 minutes. Not that anybody here has a stopwatch and is going to put a stopwatch on you, but if we could kind of keep it brief, we would appreciate that too. So with all of that being said, we've done the introduction. We do have a quorum, barely, but we have one. So we will be able to vote and approve things. So that brings us to the meeting summary from the May 23rd meeting. Do I have any comments on the meeting summary, corrections? If there's no comments or corrections, I guess we could take a motion to approve them. Motion by Ed, can I get a second?
Second.
Second by John. Everybody in favor of approving them?
Aye.
Anybody opposed? No, okay. So the meeting summary from May 23rd is approved and will get posted to the website. That brings us to subcommittee and department reports. The first thing on there was, once again, the use of the national exam versus the state exam. And I think Ed had asked that these things be put back on, so I guess maybe I'll leave it to Ed at this point.
Thank you, Mr. Chairman. Yes, I asked for this to come back on. I did read the minutes, and I just think that some of the rationale that the state is given for rejecting a national exam, which, to be redundant, is accepted in approximately 36 states in five.
Could you hold the mic up to your mouth?
36 states and
Thank you.
5 provinces in Canada. How's that? Okay? Lost my train of thought. It shouldn't be a cost issue, and I see in the minutes that the state made, or in particular, the chairman, made a comment that it's cheaper. But it shouldn't really be a cost issue to do it right. But it's not really a cost issue anyhow, in that it's similar in cost. I think the cost issue is for the state of New York to try to keep the requirements or the state exams current. So it takes a number of people, where on a national basis, I think it's done automatically. I looked at the syllabus, which is current, but not current. It's a current syllabus, but it's based on stuff that we did in 1999. The syllabus still includes transistors, resistors, capacitors, class A, B, C, or A, B, D, H, linear amplifiers, peak clipping, and nothing about what we're really doing today. So that leads me to believe that our exam is not current. And also, we had a committee to talk about the exam. We were all, those of us who were on the committee, and I was, we were approved, we did a confidentiality thing, but we never really met to discuss the exam, so I don't know where we are there. My point is that the state of New York may have a vested interest in doing the exam, and I don't know what that is, other than maybe keep our people busy, but they're already busy, so that can't be a real rationale for it. The fact that we have the exam and we like that, I understand that, but that can't be a good rationale for keeping the exam either. I think it has to be something that is good for everybody. And I think that we want to be able to have the dispensers take an exam that's fair and unbiased, and I'm sure the state has one that's similar, but that's national, so that our dispensers in New York State are as good as and meet the basic requirements of anybody else dispensing hearing aids in the United States. And I think that's one way to do it, is to have a national exam. The audiologists have a national exam for the education department. The education department doesn't print an exam for us. Lawyers have a state exam, but they also take a regional exam. So I think that the precedent is there for the state of New York, and I'm unclear of what the resistance is, Mr. Simon, in allowing the dispensers to take a national exam. I have I don't benefit at all by doing this, other than I'm always interested in a level playing field. I believe that we should protect consumers. That's what this board's all about. We should be able to have well-educated people, but I think we should also be current with what's going on around the country. And I don't see that happening in New York State. Reciprocity is another issue we'll deal with next, but for the exam itself, I'm unclear, and I was hoping that the deputy would be here to hear this. I'm sorry he's not, because I think it's important that we have put as many people in a position to help consumers, create jobs, solve problems, and get people who need this prosthesis, this hearing aid, to obtain it, and with an ease of effort. And that's not happening. We only have 320 dispensaries in New York State, approximately. We have like 700 audiologists. So it's difficult, as it is, to find people. We can't cover the whole state. If you look at geographically where they are, they're in the metropolitan areas. They're not in the Adirondacks. They're not in the Finger Lakes region. They're not in the southern tier of New York. There are very few people, so we're not really meeting the need. Not that a national exam will meet the need, but at least we're doing things that bring us to a level that we're competitive and equal to other people in this country. And I am requesting, even by vote from this board, what our position is as board members. And I think I have to take exception also, if I may please, in that we really been here for 10 years, 12 years, they said, and a lot of what we say seems to be either academic or falls on deaf ears by the state of New York and the Department of State. I defend the Department of State all the time. I say that you guys are gentle, you're kind, you work hard, and I really believe that. But we have a problem in dragging our feet. Either we have ownership in it, and I know that it's hard to give up stuff, like an exam, when we have ownership in it, and we probably think we're good at it. But I think that we need to revisit this, and if the members of the board support such an exam, then I believe it's incumbent on the Secretary of State to listen to the board. We're the professionals. We're the ones who are in the front line. We are the ones who see the patients. We are the ones who are responsible through our practices and the facilities in which we work to protect the consumer. So I implore the Secretary of State, now again, I'm sorry that the deputy's not here to hear this, but I implore the Secretary of State and the members of the Secretary of State's, the Department of State rather, to allow us to utilize a national exam. And I'm open for comments, but I'd like to finish any other comments with a vote from this board on whether they support a national exam or not. Thank you.
From the standpoint of viewing applicants that come through the system and having to test them, I see that it's very broken. We don't have a system set up in order to educate and prepare people properly for examinations for dispensing. I have openly stated to Fred and Ed that at this point, it becomes so disappointing to me, people calling me up asking me what to study, how to prepare their employees for learning the business, for taking the exam, etc., and I don't really have something substantial to give them. By going forward with what Ed is suggesting, there is an entire structure there to prepare trainers to teach these people to take the exams, and that is a structure that is pretty national throughout the country. I have
Anybody else have any comment? Anybody else have any comments? If not, then I'm going to speak for a couple minutes. And you have a number of valid points, in my opinion, a number of valid points. But I'll also say that some of them are unrelated. I mean, not unrelated. They're related, but they all don't go toward the exam. Certainly, if the curriculum needs to be updated, then it needs to be updated. It should be, we should work to update the curriculum. The exam should then be, if we're going to update the exam, it should be made updated to the most current curriculum and cover the same topics. It would make no sense to do one independently of the other, because you can't expect the people to be trained under the one thing and tested on something else, or vice versa. So they're both valid, but you got to do one before you do the other. Bringing people in, I mean, going to a national exam, having a set thing, is still not going to necessarily bring people in. I mean, I can't imagine that people just aren't coming into the business to be a dispenser because there's not in your estimation, a better system for training or whatever. I mean, I agree. It probably would be if it was a more structured type of thing as compared to allowing, hearing aid dispensers to train, and they're on their own. So that I don't know that it's necessarily as consistent as it can be. It probably depends on the person doing it and how much effort that they've done. So I mean, I understand all of that as well. And maybe something could be done to go toward that. Like I said, so that's also valid, but it's not going to increase. Truthfully, I think the way the law was set up, the way it was agreed to, still, my opinion, going back, that the dispensers kind of sold themselves out to get the licensing law changed to people down the road. It's much more difficult for them. There's many more requirements. It's not as easy as just bringing somebody in and training them. They have to have college. They have to do this. They have to do that now. And it's much tougher to get in. The majority of the people that we see, and John speaks certainly from experience. He is a practical examiner for us. But the majority of people you probably see are the audiology.
90%, 95%.
Right. So I mean, it's not a lot of the people, and you're right. They probably don't have necessarily the greatest foundation for how to prepare, because it depends on who's training them. I certainly know some people who are in the business and train people, and they do I think a pretty good job at it. But I'm sure there's other ones out there who, like in a lot of businesses, they want more of a worker as compared to somebody that they're training. So all of those things go together. The state exam, yes, I mean, we kind of said we want to stick with ours, and I will openly admit that we haven't gotten to it yet. We have a big, huge e-licensing project that's a statewide project that's kept us just under the gun to get that done. It's ongoing. There's just so much staff, so much time, and we will, we're committed to doing it, but I think if the concept of the curriculum being revised or updated or looked at, then that probably should come first. Even so, I mean, there's no sense in doing the exam if you're going to change the curriculum. So I think that's an option, and that probably can be looked at to see if the curriculum should be updated and where it needs to be updated, and then the exam would fall afterwards, even the discussion. The national exam, there's not one national exam. I mean, there is a national exam that Fred has discussed before the board, but in reality, even if we were to agree to do something, I mean, that would be something where there's other testing companies out there. But I mean, you can't just pick and choose which one you want either. So even if that were to come up, not that I'm suggesting that we're going there, but you couldn't pick the one you want. It would have to be a competitive type of thing.
Keith, you're working hard at this, and I appreciate that. Here's what I try not to be confrontational, believe it or not, but I feel that you're being really resistant here. One of the things you said that I think is very germane to this discussion, and the reason for doing what I'm suggesting we do, is that you haven't gotten to it. Your words. You haven't gotten to the test. It's been a year and a half that we haven't gotten to it. And now the first thing we want to do.
Well, I have to disagree. It hasn't been a year and a half.
Oh, okay. I'm sorry. A year? Okay.
Not exactly sure, but it's not a year yet.
And the other thing you said was the first thing we need to do is redo the syllabus. Well, we haven't gotten to that yet either, and the syllabus is really not current. So those are reasons to have a national exam, is that we can't keep up. The Department of State cannot keep up. And being resistant for the sake of resistant is either that we dig in, or it's a job security issue. I don't know. I hope not. That would be really terrible and not germane to this discussion. And the part that you said was, which is again an aside to rationalize, is that the dispensers sold themselves out to get this, in establishing the position to get this law passed. Well, if that's the case, and we admit that they sold themselves out, then we should make some corrections so that people can have an exam that's appropriate. And then, which brings us to the topic later on reciprocity. If we sold ourselves out and we make it so difficult to work in New York State, we need to make changes. And I know that our attorney is going to say that that's a legislative issue, which I disagree with, by the way. I think it can be what's the word I'm looking for? A regulation, but we'll discuss that later. So I don't know why we're not doing it. So here's what I'd like you to do. I request from you, please, is give us a succinct reason why we can't do the exam, other than there's more than one person, more than one group out there who gives the exam. What's the reason that we can't give up the exam?
There's no reason we can't give up the exam. I just said that we feel that our
not
exam,
to do it, but why?
Well, we feel our exam, generally meets the requirements that it's intended to do, which is to separate the whatever. But like I said, and you're pointing, I know you're going to point to the curriculum again, but they're two separate things. We have to separate that. Now you've brought that up, and that's fine. It's a valid point. But you can't keep, I'll be honest, and I'm not overly defensive, I become defensive when it seems like you keep coming back to the exam, but you have all these other things. So you'd have to correct all of these other things independent of the exam. You can't say, well, the curriculum, so we should change the exam. We're not getting enough people in because it's difficult for them to do 2 years of college and to do this. So if we change the exam.
Why don't we have why are we refusing to give up the exam? That's all I want to know. Why?
Because we feel that our exam does what it's intended to do. It does it as well. But like I said, it doesn't bring more people into the profession. None of these things bring, I mean, I think you try to hit some key things, which is, create jobs and all that, but it's not the exam that's preventing these people from getting a job or from producing more jobs. It's not the exam.
I will agree with you on that point, and you're not going to be drawing people into this field. People don't, I have not met anybody, unless their father's in this business, who turns around and says, oh, I just wanted to grow up and be a hearing aid dispenser. Not the case. You do it for business, you do it to make a living. To answer one of the problems, which is updating the exam, which takes effort, which takes time, which takes man hours, there are a board of PhDs that do the international licensing exam, a board of PhDs that do yearly updates on the exam. That is no cost to the state. That does not take Department of Education time, and that could be something that is very feasibly used here. When the 2-year education is thrown up in terms of the reciprocity issue, our education for this law is nonsense. The 60 or 64 credits, my credits in police science from the 60s or 70s could have been applicable, and it's ridiculous. It has no bearing whatsoever on the field that we're in. Reciprocity. Ed wants me to stay with the exam. There are ways of making this structured, giving us a foundation to build on this thing. Otherwise, as I said before, there's really no point in even having dispensers come into the field as dispensers. Might as well just stick with what's out there coming out of the 4 or 8 year colleges, whatever the hell that is.
And I agree, and I don't want you to think I'm just, being the anti-Ed. I'm not. I mean, Ed, like I said, Ed has, they're valid points, but as you can see, what it more comes down to is maybe more of the effort should be into looking at, and like I said, that the thing about selling out, that was my opinion based on how long that law had been, and from talking to people here who initially dealt with it. I mean, it took a long time for that law to get passed, and obviously it went back and forth, and eventually people had a compromise to get them to do it, and that's just, so that's kind of what I've heard from other people, that they've made it just very difficult to get in. But I mean, maybe the bigger picture is that the whole thing needs to be looked at. Maybe, and I'm not exactly sure how that would get done. Obviously, it's going to be some legislative thing, and Whitney can talk to that. But maybe the whole process of a more formal type of educational requirement, more consistency, or somehow, I'm just speaking in general terms, but it's not just the exam. I mean, it's the whole package. I mean,
we know that's broken.
Okay, right, and Ed, you said that, Ed said that, and that are all, like I said, valid points, but it all doesn't get fixed by going to a national exam, and I understand that.
It's nobody's throwing stones at you. No. We know that you're under a certain amount of bureaucratic pressure, and you're responding as a representative of the state. We're not, and to Ed's point, not getting valid responses as to why we can't move forward. He is a practical guy who says this needs to be done. Let's do it. That's all.
So let's move forward. I think this is the second or third board meeting where we've discussed this issue. If we need to look at the curriculum, let's do it. Let's get a subcommittee, let's have a meeting set before we leave, and let's get into the curriculum. Because I agree with Keith. You need to address the curriculum if it's outdated before you get to the examination. And if after we do that, we decide that, maybe there is merit to a national exam, let's explore it, but we have to take this step by step. You don't go to an examination if you have a broken curriculum.
I disagree, Whitney. with all due respect. I mentioned the curriculum, maybe inadvertently I threw up a smoke screen. I didn't mean to do that. The exam is the issue. We don't care about the curriculum. The curriculum is outdated. But with the national exam comes a prepared curriculum already. So we don't need to do that either. So again, the resistance is, why don't we move forward with the exam? Forget the curriculum. We'll get a curriculum when we get if we can decide to do a national exam.
I'd like to hear from some other board members on this issue.
Okay.
I know we've heard from Ed and John. Like I said, this has been on the agenda several times, but I'd like to get some feedback from the other board members and how you feel about it.
Keith? Keith?
Is you board member?
Keith?
Yes.
We have a member of the public wants to know if she can comment on what's being discussed.
Not during this period. She certainly can respond during the public comment period and make a comment at that point.
I have a question. How many of the states are using the national exam at this point?
39.
Plus 4 provinces in Canada. She didn't hear that, tell her.
And of 39 states and 4 provinces. Buffalo. And?
I just have a few comments. First, when we're looking at the state versus the national exam, obviously one of the big issues seems to be the training programs. I would think for consumer protection, we would want individuals licensed who were able to pass either of the exams, either the state or the national exam. And it seems to me that the issue is more on the lack of the training programs. And my question is it the responsibility of this board to be discussing setting up training programs so that individuals would be able to pass a test? Or are we looking to just get an exam that more individuals can pass?
I think that's a good question. For me, it's not an issue of getting people to pass an exam. It's to have an exam that is legitimate and meets the needs of the test takers in New York State. Our exam hasn't been reviewed in a long time. The committee that was supposed to review it, as Keith mentioned, has not reviewed it for a while. As far as education goes, or setting up programs, I don't think that that's in play or needs to be. For me, it's just the exam, that's all. Let's get an exam that is current, meets the needs, because in the hearing aid world, or the world of hearing aids, they keep changing, and it's impossible for people who are not professionally educated about the technology in hearing aids. The consumer once again suffers. So that's my point, I guess. The consumer suffers because there's people writing for an exam who don't know about the hearing aids. They're in the Department of State. Whereas if you had, audiologists and or dispensers who were current in the technology, then I think we have more legitimacy. That's my point.
Any other board members?
Just another question. So currently, who's overseeing the state exam?
The state, we do. The state does. The Department of State does.
And there's no audiologist within that group that oversees the test?
Well, there's subject matter experts when it was developed, and Ed was part of the group. So, yes, we don't do it in a vacuum here with just staff people. It has been done with subject matter experts. So people who are audiologists, people who are hearing aid dispensers, people that have been in the business and know it. So, that's how the process is done. And like I said, we had set up a subcommittee, and like I said, we haven't gotten to it yet. We're committed to getting there. But more things have get brought up here. But so now, and not to delay it further, but you can't just ignore the curriculum. You can't expect people to pass a test or be able to pass a test if you're not requiring them to learn that knowledge. So you can't put one before the other. I mean, you'd have to then make sure that the curriculum is providing them that knowledge so that they can take a test to pass it. You can't just say, I just want to change the exam to be current. If the curriculum is not current at this point, that should be changed first. If the training program doesn't quite meet the needs from what it was originally set up, then you might need to go further back in the process and say, let's change the training program first. Once we set that up, we'll come up with our curriculum or however we decide to do it, and then we'll talk about the exams, you know, like as Whitney had said. I mean, that could be discussed, but things have to be done in order. You know, I don't really have an answer why it's just the exam either.
Well, how often do you meet to update the curriculum, whether it's the curriculum or the test? Do you meet at regular intervals to make sure that that's being done?
You know, it probably, it should be done more often than it's done.
The last time I was involved in it, we were involved was in 1999. And we've talked about it several times over the last number of years, and then we decided approximately a year ago that we would establish a committee to review it. So it hasn't been done. So as far as I know, the audiology have not participated in it, or the dispensers.
But they would. I think we need to, you know, if we want to get something done and something accomplished, I guess I think we should set up a subcommittee to look and see which one we're doing first. I mean, I think you need to do the curriculum. It's my opinion you need to do the curriculum first before you can then decide on testing them on that newer information.
So I guess the question then is, are the test questions, the actual questions were written in 1999? Is that true?
Probably, yeah. I mean, with some, yeah, I mean, there's been some, you know, we certainly look at it to make sure there's nothing in there that's completely not in line with whatever. But I mean, we have to also test on the curriculum that's out there. I mean, that's in any one of our licensing disciplines, can test them on one thing, teach them something else. They kind of have to be married. So in this case, if the curriculum hasn't been updated in a while either, then we should do that first.
It seems to me you'd have to do them at the same time. Because if you give somebody the new curriculum and the old test, they're not going to do very well.
No, but you do the one first. So you do the curriculum first, and then you have to set a date for when it becomes effective, and then the test gets done at the same time so that they're tested on the new materials.
Revised 3 or 4 years ago, curriculum was
So
revised, exam was revised.
What's the state's point of view on how frequently a test like this should be updated? That seems like a long time to me.
Well, actually, I should backtrack. Jody just reminded me that the curriculum was updated about 3 years ago, and anything that was updated there was updated on the exams as well. Whatever changes were done to that. Now remember, there's a written exam and there's a practical exam, so you know there's two portions to the exam.
Yeah, you're right. I just got the wrong. Right, optometrist.
It's the New York law.
That's
what was updated.
right, because the NT would be like that.
So I would have to say, I guess I would agree with Ed in the sense that, you know, you either want to have a regular updating of an exam like this to be timely, or use somebody who does this for you, but probably asking questions from 1999 is not the best, you know, probably not the best approach in my opinion. And so you either have to have a robust internal process, or you could outsource it. But and I wouldn't advocate for. If we had a vote, I would probably abstain because I don't feel like I have an investment in it or know enough about it. But I would think that if you were going to do an internal exam, that there should be a standard and how often it's updated and kind of a schedule that's stuck to make sure that it stays current. And otherwise, you risk, you know, testing people. The devices now are way, way, way different than they were 14 years ago. It's a whole different. I mean, it's a whole different thing.
So what can we can we agree to have, I mean, we have a subcommittee that was for the exam. Would that same subcommittee be willing to look at a more broad picture of, it could be all of those things that Anthony had just mentioned. It could be looking at the curriculum, looking at the exam, deciding on maybe setting up some parameters that say, you know, we do it on a more regular basis. You know, I mean, all of those things can be looked at.
I think that's a good point. Some of our other boards, we have standing subcommittees that meet on a regular basis. For example, in real estate, we have what's called the Trends Committee, so that we're constantly looking at these issues. I think this is a perfect area for a committee like that, to constantly look at our curriculum and our examination. We have a subcommittee already. Is anybody else interested in participating? No? Okay, well then, Carol, you have a date for us, and send it to the subcommittee members. I would also like to participate. And we'll add this as an action item for a report on progress at the next board meeting. Okay.
Why not have a subcommittee rather than start like this, which is just gonna represent more bureaucratic slowdown? Why not have a subcommittee that actually looks at this entire foundation process that is being presented, and I'm sorry, it's outside of the state parameters, that looks at everything, the exam that's been put together by these PhDs, the process for training applicants on a national level. These other 39 states cannot all be running around with their heads in the sand. There's got to be a reason why it's working for them, and they have some success. We don't have to slow down. We don't have to cost the state of New York more money. We can actually review this thing and see from the ground up, is it going to work? If not, throw it out the window, put it away. But I don't see anything else that's going to happen here.
That's exactly what I was proposing, John. It's a global committee called Education Exam, but look at the entire process.
Okay.
Which I'm assuming you're saying includes reviewing the national exam along and comparing it to our exam.
Yes, we can look at both.
Exactly.
And then if we find, if the committee decides that maybe the state exam is better, we choose that. If they decide that the national exam is superior, we would then move to suggest that we accept that.
Those are both possibilities, but let's get our first meeting scheduled and we'll discuss our framework.
I can accept that. I like that. Thank you.
Next thing on the agenda is the internet dispensing of hearing aids, and I think Whitney just needs to speak to that. That was an issue that's been ongoing.
Yes, I think I'm on these next two issues. Internet dispensing of hearing aids. We do have a standing subcommittee on this topic. After our first several meetings, the department received a complaint against, I forget the name of the health insurance company that is dispensing hearing aids over the internet. So we have an open enforcement case. Their counsel has raised an interesting legal argument that the state of New York may be preempted from enacting any regulations on this topic because it's an issue that's preempted by the FDA. So I'm in the process of researching it with our general counsel and another attorney on my staff, Dave Mossberg, who's in New York City. And we're hoping to have an answer on what our jurisdiction is in the near future. And after we establish what our jurisdiction is, then we can decide what our step is going to be as a state.
Can you elaborate a little bit on what the FDA statute is, or what they're hanging their hat on?
They're arguing that a hearing aid is a medical device that's regulated by the FDA, and that the FDA may have preempted the issue, meaning may have retained sole jurisdiction of the issue, which would prevent states from enacting any laws or regulations that were different from anything on the federal level. It's an interesting argument. I don't want to get into whether I agree or disagree, since I'm just one of the members of the legal staff who's reviewing it. But I believe that we're getting close, and hopefully by the next meeting I'll be able to have a more substantive discussion with you.
Was that the Commerce Clause that they were using?
No, it's different. It's different from the Commerce Clause. Okay. The next issue, allowing out-of-state experience. I understand that Ed disagrees with me. Certainly respect your opinion. I do feel that this is a legislative issue. We have a very specific provision in our statute pertaining to what we can consider as far as out-of-state licensure. We have to look to make sure that the out-of-state requirements are equivalent to or higher than those in effect pursuant to our statute. So we have submitted a legislative change for consideration as a departmental. We've made it part of a global open for business bill proposal that combines this legislative change with some other changes to other licensing statutes, which we believe are restrictive, to open up business in New York.
What does that mean? Can you explain some more?
Yeah, every legislative session, the department is allowed to make what we call bill proposals, suggested changes to statutes. So we submitted, I believe, 2 or 3 proposals from the licensing division, and this was one of them. You gave us some great language, Ed. I think it was based on years of experience, 5 years versus 3 years. So that would be the language we'd be looking at. It's been submitted to the governor's office for consideration. So we'll see where it goes.
Well, I'm impressed. I didn't know that. So, Baba, sorry.
It does take a while.
It does take a while. I mean, unfortunately, there's a process. There's a legislative process that we have to follow. And if we're unsuccessful with the bill proposal, then we'll go back to the drawing board and look at what other options we may have.
So the items that we talked about a number of months ago, a number of meetings ago, is what we're submitting that, in lieu of 2 years.
Yeah, it was 5 years of experience would be accepted for licensing in lieu of 2 years of college, and they'd be required to take only the ear mold exam, and then there was a 3-year component. Those with 3 or more years of experience and 2 years of college would be accepted for licensing in New York and required to only take the ear mold exam.
That's good. That is what I said. Thank you. Okay, I'm quiet.
This meeting, there are no action items, so we'll move on to new business. And I think we labeled this consumer education, but this is the topic which I think Florence would like to speak to on regard to the telecoils, and I think it was in that vein of allowing the consumers to be more knowledgeable about their uses and so forth. So, but I don't want to speak to Florence, so I'll let Florence speak.
I prepared some notes.
I don't think you need that, well, unless you need to hear yourself.
I don't, matter if I don't hear myself. When the American with Disabilities Act was passed in 1990, doors began to open for many people with disabilities. Today, we routinely see handicap ramps for people with physical disabilities, which allows them to enter government offices, libraries, stores, and restaurants. I would like you to consider for a moment what would happen if these physical ramps were removed or blocked or did not exist. Think about the impact that the loss of access would have on people with physical disabilities and on our society as a whole. Now, consider the access issues of the hard of hearing, an invisible disability, a population which is largely without any form of public hearing accessibility. This is very disappointing, since people with a hearing loss need their handicap ramp also. Linda, and the article is in your folder, Rema Schneider, an audiologist whose Chicago office provides speech rehabilitation and assistive technology to all their clients, has written extensively on the subject of access. Dr. Remensnyder says people who are fitted with hearing devices simply want to hear. They don't want little tiny hearing aids that nobody can see. They want to be able to hear. And they want to be able to hear in every type of situation that they are in. Is this too much to ask for us or expect in 2013 when the hearing world is effortlessly connected in every possible way? Handicap ramps for people with hearing loss are induction loops and T-coils. T-coils is more in part, and other FM and infrared assistive devices. For illustrative purposes, after my formal presentation, I will show you how I use my T-coil, not for the telephone, but for other equipment. When sound travels from the speaker's mouth through the induction loop, or using an FM or an infrared system, to the T-coil, hearing aid background noise is effectively eliminated. The result is excellent sound quality, since the signal-to-noise ratio is no longer an issue. And I want to give an example. Last summer, I went out to Portland for the Hearing Loss Association annual convention. I was late in getting my tickets, getting everything organized. The only seat I could get at the banquet was in the very back. I thought, oh no, this is going to be a disaster. I won't hear a word that is being said. So I'll just enjoy my food, and that's the best I can do. Well, the speaker started. I said, well, I'll try my T-coil. And lo and behold, I could hear every word from the back of the room that the speaker was saying. I was part of the meeting now. I wasn't sitting there just eating my food. As a result, the hearing aid user with a T-coil can hear effortlessly in public places, and that was my experience, such as place of worship, government meetings, theaters, lecture halls, classrooms, airport, and sports arena. Let me repeat it myself and emphasize, induction loops and T-coils overcome the background noise and the signal-to-noise ratio problem that are inherent in hearing aid devices not equipped with T-coils or other similar devices. In effect, T-coils and loops dramatically stretch the capabilities of hearing aids. Fortunately, New York State is one of 3 states in the nation with a T-coil law. These laws recognize the importance of the T-coil and the role they play as handicap ramps for people. General Business Law 791, and you will find that in your papers that I have there, Section 20, clearly requires that the registered hearing aid dispenser shall distribute printed educational information on the general use of hearing aids and assistive devices. In addition, New York Codes and Rules and Regulation, NYCRR, Title 19, Section 192.18, mandate New York audiologists and dispensers provide information regarding T-coil to all hearing aid recipients and provide T-coil training for all consumers whose hearing aids are equipped with a T-coil. Incidentally, this regulation was crafted by 2 former board members, Lisa Hamlin and Marcia Dugan. John, you probably remember them. Both were on hand both were hard of hearing, and they understood the critical importance of the T-coil as a device for the hearing aid. In order to maximize the effectiveness of hearing aids, we need to educate the hard of hearing as to the use of the T-coil and the potential to dramatically improve the hearing experience of users in a variety of public settings. As a board, we need to see that the existing laws and regulations on the subject are followed. Advocates like myself, through informal surveys and discussion with consumers, are seeing disturbing evidence that hearing aid professionals are not abiding by the letter and the spirit of these laws. This is deeply disturbing to me as a hard of hearing person. If someone does not have a T-coil on their hearing aid, they cannot tap into the induction loop except using an extra device. And it makes it very hard for consumers who want induction loops to put in to have people who can use it. A very real sense, the resistance by the hearing professionals to fully and enthusiastically implement these laws is equivalent to blocking the use of the handicap ramps for those of us with a hearing loss. There is much we can learn from the action taken by states Florida and Arizona in response to this problem. Florida requires that the consumer be informed about T-coils at the beginning of the process of selling a hearing aid to them, so they know what to ask for in the hearing aid. This is very important. If the counseling occurs at the end of the process, after they have already purchased the hearing aid, the result is all too often that the consumer leaves with a hearing aid not equipped with a T-coil. New York state law permits the counseling and education process to occur at the end of the process. This we need to change. Arizona sets the gold standard. It requires that the bill of sale for the hearing aid include written certification by the audiologist or the dispenser that the client has been fully informed about the function and importance of the T-coil. I strongly recommend that the Hearing Aid Dispenser Advisor Board recommend a strengthening of the current regulation to require upfront T-coil education of the client prior to the selection and the sale of the hearing aid. Further, that audiologists and dispensers be required to certify in writing that a thorough discussion was held for each client as to the function and importance of the T-coil. In my community, in the lower Hudson Valley, we have a working group on public access. We are going into theaters, we are going to libraries, and we are going to schools, trying to encourage them to put in induction loops. During the public session, you will hear from some of the people who are in New York City about their experiences and efforts. I am sure that they will underline and reinforce what I have just said. And finally, I would like to thank Keith Simon for making the New York City location of this meeting accessible for people with hearing loss and for a thorough airing of this important topic. Thank you.
I have a question.
Yes.
I must admit, I don't know much about T-coils. Why do you think that this education isn't occurring?
For several reasons. I think Ed brought up John brought up a reason. He didn't think people understood. But I have to say, I've had a T-coil since the early 90s. It is very easy to use. So maybe it's that the audiologists and the dispensers aren't well informed about T-coils. T-coils originally were for listening on the telephone, but they can do much more than a telephone. And maybe that's a misunderstanding.
I really find it hard to believe, only from my own experience, that people out there that do what we do would not be trying to enforce the use of the T-coil. And I will admit that the first thing I think of is not a loop, but the T-coil I know is so important for people on a daily basis. I applaud what you're doing right here. But just in terms of communication with their families, those of us that do this for a living know how important it is to have a T-coil in the device. We're confronted with the issue of vanity, though, and being that vanity is an issue with so many people, the tiny little receiver in the ear type products that are generally were developed only for a mild type of hearing loss, where a T-coil might not be necessary, or the very completely in the canal type of instrument doesn't have the T-coil. And I would think that most professionals would make the attempt to explain that they will not have a functional T-coil, but the idea of the loop systems being that it is pretty new, especially in New York City, and I know that now I believe it's in subways also and things like that. I think that's wonderful, but it's not the first thing we think of, and I do not know how to get the education out there to all the dispensers, but I applaud you for pushing.
I understand that you may have a problem understanding it. I included an article that says invigorate your practice with hearing loops. And this audiologist has a TV and a room that's looped, so people can find out what it's like to listen. And I think when they see how much better they hear, that vanity becomes a secondary issue and hearing becomes the first issue. I also want to say that in Europe, loops are more commonly used. And maybe that's something we should think about. Maybe we need to be doing that here, because the hard of hearing person deserves to have a ramp. It's an invisible handicap. We've avoided it. We haven't done anything about it. But the people with physical disabilities have ramps. So, John, I think maybe we do need to offer more education, but I suggest that you read this article.
Thank you.
But something else comes to mind, and certainly thank you for the information on the laws in Florida and Arizona. I'm going to be taking a look at those. But in taking a quick look at our statute this morning, I noticed that we do have a consumer brochure. Wouldn't this be another topic we could include in that?
It is in the back page on the
back page. Okay.
It's on the T-coil.
Okay.
At one place it says assistive devices.
Okay.
And that's a little hard to say whether that really includes T-coil. But I think not only for the consumers, but also for the hearing aid dispensers and audiologists need to find out how to teach it. There's sometimes people will have a T-coil on their hearing aid, and if they don't really understand it, they may press it, and then the hearing aid appears it's not working. So they need to understand how to use that T-coil. And you may have had problems with people coming in and complaining that their hearing aid's not working. There's another problem with the T-coil. Some of them are automatic, and so when you put the telephone up to it, it automatically goes on T and it goes for the hearing aid. But if you're going to use an induction loop, you want a manual T-coil so that you can pick up the sound from the induction loop. And that point needs to be made.
I agree with everything you're saying. I mentioned T-coils. I can tell you some of the problems that occur. Vanity is one of them, even with and the person that wrote the article said, you quoted that patients don't care how big the hearing aid is, as long as they can hear. I wish that was true. I don't experience that on a daily basis. One of the things that happens is when you give somebody a T-coil and you explain it to them, they come back in and they refuse to have that program in their hearing aid. And what happens is they have difficulty in finding the program. And they'll have the program on and they'll say, my hearing aid is buzzing in my ear and I can't hear anything because the T-coil's on. So that's an educational thing, but some of our patients, in all honesty, are older. I saw a guy 2 days ago. He said, he's very bright. He said, I don't want any buttons. They get buttons regardless, because maybe they change their mind later. But he says, I want ease. I don't want to have to do anything. I just want to be able to hear my wife. And I said, well, he had a big hearing loss, 50 dB. And no matter how I tried to educate him, he refused. So, I agree with you, and I think loops are important. And as the baby boomers come up to get their hearing aids, I think it'll be more ease of effort than it is with the population that we're dealing with right now. But Vanity, I got a guy the other day, he can't hear beans. And I said, we put a hearing aid on him, he's like, too big. I said, nobody can see it. I can feel it, too big. So that's a real problem for us.
You have
I just want to add to that and say to you that the automatic T-coil has given us a tremendous value in terms of being able to help people. I know that for what you're talking about with the button, excellent, works wonderfully. But you can't teach an old dog new tricks. True. They want simplicity. I put automatic T-coils in there. The button is there. But 90% of the people, I turn it off because they'll put a telephone on their ear, they'll hit the button, it'll go in and out, in and out. They get crazy, they come in complaining. I don't want to do anything. I just want it automatic. Depends on the age level, depends on the intellect of the person.
We may have issues with the manufacturers, but I'd like to go on and just show you some of the uses that I have for the T-coil besides telephone. This is a neck loop. It's basically an induction loop, but it's just small and it goes around my neck. And one of my favorite equipment is something called a conference mate. And if we didn't have this wonderful system here, this is what I would be using today. I've used it at many meetings. It's so beautiful. And I'm often accused of taping, but I'm not. I'm just trying to hear. And I take my neck loop and I plug it in here, and it automatically goes on. And then I open this up, and I have to turn the switch on right here. The light will go on, and then I'm able to hear. I can set this one here about 50 feet away. So if I'm in a group meeting, I can set it in the middle of the room and hear everybody speaking at the meeting. I have been to meetings where I didn't put it on, and I thought, boy, this is boring. What are they talking about? And then I put it on, and I suddenly realized that I could hear, and what they were saying was very interesting. This is one of my favorite things. I bought it like 1990, and I have used it, fixed it, glued it back together. There is a newer model, but this one works fine, and it is so beautiful. This is probably a piece of equipment that you both know very well. It's called a pocket talker. And again, I take my neck loop, put it in here. Turn it on. It's good in the hospital. When somebody comes in, they've left their hearing aids at home, the doctor's speaking to them, and they want to hear. You can use a headset with it instead of a neck loop, but since I have hearing aids, it's easier to use a neck loop. It's a very handy little equipment. I can take it if I'm out to dinner and I want to hear the person next to me. It's a handy little piece of equipment.
Do they have to speak right into the microphone?
Yes, this is like it picks up your voice.
But you have to speak into it?
No, you can speak a distance away. And it actually comes with a cord, so I could attach the cord and throw the mic over to you. It's very useful in the car. If I'm sitting in the back seat, I can't hear the people in the front seat. I would use this. The amazing thing, it only costs about $150, not $5,000 or $6,000 like some of the hearing aids today, and it fills a gap. And I'm a nurse, so I have to be able to hear heart sounds. I have to hear lung sounds. I have to take blood pressures. And what I use is this. I plug my neck loop into it and turn it on, and it works remarkably well. I can hear people's heartbeats, I can hear their breath sounds, and it enables me as a nurse to practice. So these T-coils do a lot of wonderful things besides just in public places. And I think we need to make sure that consumers understand about them. It may take more than one attempt. My problem wasn't understanding how to work. It was getting the audiologist to put them in the hearing aid. I had to tell them how to place it into the hearing aids at first. Now that I wear behind the ear hearing aids, they're usually in the hearing aids. So I'm going to detach myself from all this. Do you have any questions?
I have another question. My fear about putting a specific technology in a regulation or statute is that it could become obsolete at some point, and it's always difficult, as we've seen, to change a statute. Is this a technology that's evolving, or has this become fairly static?
Interestingly, the T-coils have been around for years, but I agree, there may be something better coming. And look at the Apple iPhones. It's got all kinds of apps for people who are hard of hearing. So you're right, we do have to think about that, but it is already in there. So my point is we just need to make sure that it's used and that people some way figure out how to enforce it. And I think Florida and Arizona were working on those issues.
I have a comment.
Go ahead.
Okay. I agree that T-coil information should be provided to all patients. And we all that dispense hearing devices, audiologists and non-audiologists, we understand that every patient is different. Some patients may be interested in telecoil, some patients may not. However, I think all patients should be given the information at the initial consult and given their options. And I have to say, having overseen audiologists for many years, there are probably times when a patient comes in for a specific product and is not given the information about the telecoils. So I would have no problem at all with some type of wording that the patient was given the option. Yes, telecoil technology is changing over time, but telecoils have been around forever, and it will be for quite some time. So I don't think it's a bad idea to have it written that hearing aid dispensers and audiologists should be informing people about the telecoil at the initial consult and giving them the choice of whether they want that technology or not and documenting it.
Whitney, I didn't totally answer your question. Some hearing aid companies are coming out with Bluetooth, and it's okay, but somehow I think the T-coil technology fits my needs better. And you're right, new technology is happening.
It's an interesting issue, and I think we can take a look at our statute and regulations to see how they could be strengthened. But I also think there is an educational component that we can't overlook. We're fortunate that we have the Division of Consumer Protection that's now part of the Department of State. So I'm going to suggest that we collaborate with them as well to think of ways that we can get educational information out there, so that consumers aren't just relying on their hearing aid professionals, that they're also receiving this information from the Department of State.
As a nurse, I have to, I just renewed my license. And one of the things on the nursing license was I had to do infection control. Now, I had to take a course in infection control and then prove that I had taken it. And I'm wondering, maybe we need a course on assistive devices and T-coils. And this could, of course, always be updated to the newer technology. And that people, to get their license, would have to check that off, that they've taken the course. I have to take it every 3 years. And the license is renewed every 5 years. It doesn't quite go in sync, but you still have to do it.
Sure.
As the representative for the consumer division here, I just want to try and get this straight. Are we suggesting outreach to the community, to consumers in general? Are we suggesting outreach to the professionals in the field, or are we suggesting outreach to folks that are using the devices? Or is it a myriad? Is it some sort of a combination of all of them?
It's a combination.
Okay.
We definitely, since people go to the professionals to learn about what to do about their hearing loss, the professional has a responsibility to educate the consumer. The more the consumer knows, in my case, it was backwards. I knew about T-coil,
right,
and I went to the audiologist and said, this is what I want. But that's not always true.
Okay.
I just thought of something. We do have a course on every 2 years that you have to take 1 credit of the state licensing law. And I mean, this right here, Title 19, 192-18, I wonder if that could be, if the people who teach the course, we inform them of this, the dispenser shall instruct new users of hearing aids of the basic information about how to use the hearing aid. And it goes on and it gives about 13 different things, and one of them is telecoil. That might be a nice way to do it, but it would also be nice to have something demonstrated at these meetings. You can talk about all you want until you see it. I mean, a lot of wires, but I think the loop, the induction loop, is really a nice idea for patients who want to go to a meeting, or, in all honesty, I try to think of all kinds of things. And I've used a pocket talker in hospitals, but I've never thought about using it in a car. So with a loop, I think that was outstanding. So those kinds of things, I think, could fit nicely in here already. We have a regulation. And the people who teach this, maybe we need to instruct them to include it every 2 years. Yeah, I'm willing to do it. Great.
That's a good idea.
Yeah.
I'm not. Ed, Barbara Kruger, I teach that course and I say it every time.
Can I say something?
I just wanted to finish.
This is Jerry Bergman with the Hearing Loss Association. The primary problem is not with the teaching, but with the extent to which audiologists and dispensers simply do not, as Ms. Butler said, tell the whole story about T-coils and induction loops and how they can be helpful. We understand not everybody wants one, but they should have that choice. I see Ann Orsine is nodding her head. We just think that New York can learn from Arizona and Florida and do a little more in this regard. I also have some prepared remarks after the questions.
This is Janice Schachter-Lintz, and I too will be speaking about the same issue. I'm the one that did the legal analysis between the states. Arizona is the only state in this country of the 3 states that have the law where it is on the bill of lading. And so if we already have the law that requires the audiologist to discuss the T-coil, by adding it to the bill of lading or the bill of sale, it should not be a big deal, but it ensures that it is actually being discussed. So really, we're not asking to change the law. We're just making sure that it is actually discussed, and by putting on the bill of sale, it confirms it was. Also by requiring audiologists or hearing aid dispensers to loop a room, it's getting them invested in this. And so while I agree that there are Bluetooth technology, there are connectivity issues, and when you have a severe hearing loss or more than modest degree of hearing loss, you need to ensure reliability, which you don't have. And as far as all the myriad of reasons, also T-coils can be put in CIC aids. My daughter had a CIC aid. It requires pushing the audiologist and the manufacturer. And if the state requires it, we will be amazed at what can be accomplished, because places like the Intrepid, which said they couldn't put an induction loop, when the Pentagon threatened to withdraw the shuttle, they were miraculously able to do things. And I'm the person who's responsible for the subways, the museums, the taxi induction loop. So I have heard everything that can't be done by a lot of people, and then when it's forced to be done, it's a miracle what can be done. So, I know what can be done because I worked with Bill Austin at Stark Week. It can absolutely go in CIC aid. And my daughter had at that time, moderate to severe hearing loss. But I have remarks as well, but I just wanted to address, because there are some misconceptions in this, and having studied the 3 different legislations, that all we're asking for is requiring an induction loop in an office or the place of dispensing and putting it on the bill of sale. So it's not changing the law or changing the technology. We already have a requirement in the state for it. And by the way, I'm Janice Schachter-Lintz, and I'm not in this capacity, but I'm a member of the Interagency Council for people who are deaf, blind, and hard of hearing, but I'm not here in that capacity.
In 1 second, I'm actually going to open it up, because I think at this point it's appropriate to just start the public comments. But can I just ask a couple of questions from a somewhat ill-informed person on the topic? But you say that Arizona requires that on the bill of sale they include a certification that they've gone on it, but the fact that they have it on the bill of sale, in my eyes, doesn't necessarily ensure and prove that they've talked about it. I mean, plenty of people sign things and haven't done all the things in it. So I think part of the problem is we don't have people coming forward to us. I mean, it is in the statute now that they talked about it, and I know Florence says she hears from people, but if they don't contact our department, our enforcement people, and say, look, you know what, I went and got them, and now I went out to so and so, such and such a place, and the person I was talking to, they have these things and they never discussed them. So unless they call us and make a complaint and say the person never discussed it, it's hard to enforce. So I think
you can't ask for what you don't know exists. And so when I started the induction loops in the city of New York, I brought the first induction loop to the city of New York after seeing it in England. I am an attorney, had no idea that this technology existed until I went to England and saw what was available. I brought it to New York, it started with Temple Emmanuel. Each place that I met with, no one had ever heard of it. So it's hard to complain. My theory was build it and they will come. And so even along the way, I have battled for the last 11 years, museums, subway, taxis, where they're all now, we just went into Gristides, 4 locations, Shake Shack, Apple. I battled everyone. People don't know about it, and then the old adage was, and trust me, my daughter saw the, quote, top name brand audiologist in Manhattan. everyone said, well, there aren't induction loops, so you don't really need it. Well, it's the old chicken and egg thing. And so while we can't confirm that it will be discussed if it's on the bill of sale, it is the only guarantee, short of having cameras in every single person's office. But we need people to at least, if they don't read their bill of sale, you cannot make people do things. But you can at least ensure that the information is getting into their physical hands. I think we can do things in terms of making sure brochures are delivered. I've never received a brochure from any state agency ever with all the hearing aids and doctor visits we've gone to. And we had 5 ENTs at one point when my daughter's hearing was dropping, and the name brand people, and no one ever gave it to us. So, I have more formal comments. I'm happy to discuss and really meet with even with individual members about what is the perception or what sounds great should happen versus what is the reality. It is not being discussed. There's no new technology. It can be put in. It is going all over the country and around the world. It's all over the UK. It is mandated in England that every single hearing aid that's dispensed by the National Health in England must have a telecoil. Now, we can't make that here, but we can make sure people are at least informed, and if they choose not to, that's okay. Then maybe we need a little place on the form that's where they sign saying they declined, the way we have people declining different coverage of different other things. When you rent a car, you have to decline CDW. Let's have them sign, I declined having a T-coil. But we need consumers to be informed consumers.
I have another question. How difficult is it to loop in office, and how expensive is it?
Cheap and brainless.
Well, it's not
really
brainless, but it's not difficult.
It's not difficult at all to loop an office.
$200.
It's just a
$200 to $300.
an amplifier and a wire. That's all it is.
And you put it in your ceiling or your floor.
Right. And as long as they have a T-coil, they can use the loop in the office. But I think part of the problem here in the U.S. is the fact that our standard was not looping. Our standard is infrared. And if you go to any public venue here in the U.S., you'll notice up toward the ceiling, there are little black boxes along the ceiling. Those are the infrared boxes. And the technology that most places use here in the U.S. is similar to something you've probably seen on the internet or on TV called TV ears. It's infrared.
Mm-hmm.
And, looping for some odd reason was never considered. And I haven't been an audiologist long enough to know how long the infrared has been around. But that seems to be the standard. Looping just not thought of here in the U.S. as much. Of late, thanks to people like you, yes. I got a big stack of cars. I live up in Westchester County, and we have in my town in Pleasantville, we have a place called the Jacob Burns Film Center. It's an independent film center. And I'm on there, I belong to the film center, and they know I'm an audiologist, and they sent me, 600, 800 cards, because somebody donated a looping system to them, and they put it in. They made a big announcement that they have a loop system. So, but I think part of the problem is the fact that it's really not considered the standard here in the U.S.
That's
Can I speak?
Wait, can I just say one thing to that? That's sort of accurate, but not really. It's a standard around the world, and I think, and this is a problem with the United States, is we don't look globally the way we should be, and a lot of people are not leaving this country, but if you look around the world, in the Scandinavian countries and the Commonwealth countries, it is standard. The problem is putting in an infrared system or an FM system in a venue is easier for the contractor. While it's only about $275 to loop an office, in a larger space, it's more complicated. You need to understand math, look at architectural drawings. And so we have to think about, is it better for the person who's using the device or the contractor? In most places, we're doing ADA compliance. Let's do what we need to get a C of O. We are now shifting to a customer service approach, where what's best for the consumer not wearing a device. That's why Nederlander just put it into 2 theaters, and why Shake Shack put it in Gristedes. We have an aging population, 30% above age 65, people living longer. People don't want to wear devices. Bloomberg wears hearing aids, yet sometimes he doesn't wear a device. Clinton wears hearing aids, never seen him wear a device. People don't want to wear devices and receivers. So access is not effective if it's not used. And we need to change from just ADA compliance to providing excellent customer service to all of our people. And when venues view it that way, they're shifting to induction loops because nobody wants to wear a device around their neck that says, here I am, hearing loss person. You know, we've moved away from even using the handicapped word where that's really not politically correct. And New York State enacted person-first terminology by Governor Spitzer for that very reason. We have to shift to a consumer-oriented thing, and the state dispensary should be moving in that same venue. So we've got to change our focus to what's global, and I'm the only organization that's tracking best practices around the world. And I can tell you, if you want to go country by country, where induction loops are and in what venues and I can do a full, complete photo montage and do that at the next meeting if you'd like, because I've done this around the world. I'm speaking in Ecuador at the World Disability Conference on this exact issue. Sorry, I didn't mean to interrupt.
All right, this is Jerry Bergman. I happen to be the acting chair of the Looping Committee here in New York City for the Hearing Loss Association. I also was at a conference in England last month called the International Looping Conference, and there were representatives from many, many European countries, even someone there from Africa, and a contingent of 26 people from the United States. These are the people who've been in the forefront of the looping movement here in the U.S. And New York has been behind other states in this regard. If you look at what's happened in the state of Michigan, you'll be amazed. They've looped the Grand Rapids Airport. They've looped sports stadiums, Michigan's football stadium. This is in old technology. I had 4 audiologists. The first 2 never mentioned T-coils at all. The third one, when I asked him about T-coils, poo-pooed T-coils, said it's old technology, go with Bluetooth. And I didn't even have a Bluetooth-enabled hearing aids in both ears at that time. Someone mentioned about applications in healthcare settings like hospitals. Telecoils enable you to use induction loops in a variety of ways. A room loop is only one of them. A chair loop for somebody in their television room is another one. In a hospital, nurses and doctors can walk around with a loop clipboard, and people who have hearing devices can hear that way wirelessly. I think I appreciate what was said before about the practices in the United States. I wouldn't use the word standards. Those have been previous practices, but as Janice mentioned, the world standard today is telecoils, and as Fluffy mentioned, there's a tremendous range of accessibility as long as we have telecoils. And I'd like to elaborate a little bit in my prepared remarks when I have the chance.
Yeah, let's get right to those public comments because we've gone
Okay,
back and forth.
if I may go first. Thank you, Mr. Simon.
Can you wait for him to call on people first?
I thought he.
No,
I'm sorry,
he didn't. No, he didn't.
Oh, I'm sorry.
I just want to do it orderly, so, I don't care who starts down there. I think most of the people that want to make public comments are down there. We have, I'm sure, a couple here in Albany also, but you can just state your name so that we can have it for the record. And like I said at the beginning, if you could kind of try to keep it within about 5 minutes. Like I said, nobody's going to put a stopwatch on it, but keep it fairly brief. It would be appreciated, and everybody can get an opportunity. So, go ahead, Jerry. If you want to start, go ahead.
Yeah, thank you, Mr. Simon, Ms. Fansler, and the Department of State for this opportunity. I'm thrilled by the discussion so far and your interest in accessibility for people with hearing loss. Over the last 8 years, I lost most of my ability to hear and now depend on a cochlear implant and a hearing aid. With the help of the Hearing Loss Association of America, HLAA, and its New York City chapter, I've gradually learned how hearing loss affects people and how we can conquer our disability and live active, rewarding lives regardless of our age. I speak to you today as chair of the Hearing Accommodation Task Force of New York, acting chair of the Looping Committee, and incoming president of the New York State Hearing Loss Association. I wanted to learn all I could about this body, and I believe there are 2 very important areas that you can make a real difference. One is to support regulations and policies to make it easier and more affordable for people to receive good quality hearing care and obtain hearing devices. I think that's a principle that you should strive for as you consider the issues such as internet sales. I won't say more on that. The second is to promote the availability and use of telecoils in hearing devices and induction or hearing loops in various places of public accommodation. What Mrs. Butler so eloquently described as our ramp for hearing access to prayers and sermons in houses of worship, town council sessions, school board meetings, and debates among candidates for public office. Right now, many of those places don't have infrared systems or any listening system, and those that do give you a headset. This has been the practice for the last 20 years since the first Americans with Disabilities law, and those of us who wear hearing devices cannot wear headphones. They just simply don't work for us. Reliable estimates are that only 20% of people with hearing loss use hearing devices. That means that over 3 million New Yorkers either don't have hearing devices or don't use the ones they have. Restricting access to hearing care and hearing devices by preventing sales by mail order, internet, or big box stores seems like the wrong way to go. I won't say any more on that. Those of us working to bring hearing accessibility to people with hearing loss know the magic in the small telecoil. This is something that costs a manufacturer about $2 to put in a hearing device. So, we can't let the community tell us that it's something that people can't afford. Now, the only reason I know people cannot hear with telecoils is either they weren't sold a device with a T-coil, or they were not adequately informed of its benefits. I fall into the latter category. I wasn't instructed or told anything about the T-coil, and the third audiologist simply told me how to use it with the telephone. The list of venues with hearing loops, as you've heard, is growing exponentially. Hundreds and hundreds of houses of worship, cultural institutions, libraries, the subways, airports, sports arenas, stadiums. My wife and I were in Moscow briefly, here before last, and we were amazed to see the symbol for induction loop in the Moscow airport. As I said, it's starting to happen here. On Friday, I'll attend a lecture on investments in the economy, a day-long session at New York's 3,800-seat Metropolitan Opera House. Thanks only to my T-coils, I will be able to hear and understand speakers by wearing a neck loop to stream the house's infrared signal to my hearing devices. So it's not either telecoils or infrared, it's both of the above. And the idea is to maximize the technology for the benefit of people with hearing loss. Perhaps this board can look into ways of better enforcing requirements in the current law, that professionals provide both written information on T-coils to their recipients of hearing aids and training in the use of T-coils. Many hearing care providers, we believe, are unaware of this requirement. We're going to try to document this by a survey of all the HLA members in New York State and ask them how many of them were told about telecoils when they were dispensed devices. And we will give you that information. My other question is, how can such training be given when so many dispensing offices do not even have a room with an induction loop? We have suggested in a paper in your packets how some new provisions in the law would promote more awareness of the advantages of T-coils and in turn boost demand for the installation of more loops. Thank you for the opportunity to address this body.
Thank you. Next public member.
May I?
Sure.
Hello, my name is Janice Schachter-Lintz, and I'm the chair of the Hearing Access Program. I'm also the mother of a 19-year-old daughter who is hard of hearing. We need New Yorkers to become informed consumers about their hearing aids and their features. As Cy Sims said, an informed consumer is our best customer. We need the Hearing Aid Dispensing Board to, 1, ensure that hearing aid features have generic names. Hearing aids offer a number of features, but it is difficult for consumers, audiologists, and hearing aid dispensers to compare brands. Manufacturers do not use generic names for features, and many manufacturers trademark the names they use. Comparing features is virtually impossible without consistent names. Users and parents of children with hearing loss are dependent on the audiologist or hearing aid dispenser to provide information which may present a conflict of interest because the audiologist hearing aid dispenser, 1, does not represent all manufacturers nor have knowledge of all hearing aids on the market. Audiologist hearing aid dispensers are presumed to know all the aids on the market, but the reality is that they only dispense a few brands. The hearing aid mix they offer is based on such concerns such as, but not limited to, the percentage of earnings, incentive pricing, delivery schedule, quality, and customer support. Some of these concerns, such as percentage of earnings, are not in the best interest of the consumer. They may receive bonuses or equipment based on the volume of hearing aids sold. Many hearing aids provide free equipment or incentives or perks such as trips to audiologist hearing aid dispensers based on their sales volume. This market program is now frowned on in the pharmaceutical business and should be eliminated in the hearing aid business as well. Has a financial incentive to maximize the likelihood of making a sale. Audiologist hearing aid dispensers make a substantial profit when they sell hearing aids. Critical information that may obstruct or delay the sale, such as the pros and cons of features, may not be disclosed. The New York State Hearing Aid Dispensing Board can bring greater transparency and accountability to the dispensing of hearing aids by standardizing the names of hearing aid features. The second issue, as we discussed, is ensuring that hearing aid dispensers inform their patients about the benefits of having a telecoil, also known as a T-coil or T-switch technology in their hearing aids. Hearing aids with a telecoil receive sound directly via magnetic induction from hearing aid compatible phones, all landlines and select cell phones, induction loop assistive listening systems, or device containing an inductive coupler. The telecoil setting maximizes the customized output of the person's own hearing aid. The additional benefit is that the telecoil users do not need a receiver for the induction loop systems. New York State already has legislation that requires hearing aid dispensers to instruct new users of hearing aids on basic information about how to use the aid. The training should include, at a minimum, the following use of a telecoil switch. And I've included in my handout, which I don't believe you have, but can be sent to you, but has both Florida State and Arizona legislation for your convenience. Arizona and Florida have similar legislation, but only Arizona requires that the bill of sale contain language that verifies that the client has been informed about the telecoil, including benefits such as increased access to telephones, assistive listening devices, its proper use, and the switch is also referred to as a telecoil, T-coil, or T-switch. This requirement ensures that the consumer was advised and provides teeth for enforcement. The current New York State law provides no safety net to ensure compliance. Some reasons that have been given by hearing aid dispensers for not advising about the telecoil include they think clients will think they're being charged extra for unnecessary options. Telecoils are quite inexpensive. The feature is unnecessary. In reality, telecoils facilitate communication on the phone and via assistive technology. The client's fingers may not be nimble enough to maneuver the switch, seldom an issue, and somehow they get those batteries in the hearing aid. So, not always. A child may inadvertently switch the aid to the T setting and not hear. Today's children are very technologically savvy, and there are 1-year-olds who are using iPads better than I can. And children who receive benefit will want to hear and will adjust quickly to the settings. T-coils cannot be included in CIC aids. They can, and my daughter had it. Legislation should require that telecoils be demonstrated so consumers understand what they are purchasing or decline knowledgeably if they choose not to have telecoils in their hearing aids. All new cochlear implant devices now have a telecoil. An induction loop should be installed in every hearing aid dispenser's office to demonstrate the potential benefits of the telecoil. Arizona supported hearing aid dispensers by developing a free telecoil brochure where the hearing aid dispenser can place their own branding on it and hand it out to consumers, and that became an incentive to actually distribute it. In summary, regulation of hearing aid feature terminology is critical to enable consumers to be educated and not dependent exclusively on the audiologist hearing aid dispenser. There is no incentive by the manufacturers of vendors to provide this information. It's pretty similar to purchasing a mattress. It's impossible to compare. Therefore, hearing aid dispensers and audiologists should ensure that the information is made available so that consumers become better informed and more satisfied with their purchase, which we can all agree will be beneficial to everyone. New York State legislation should be amended to follow Arizona's model, which I've attached, which requires the hearing aid bills of sale include language indicating that purchasers were advised of a telecoil option and tested it. I believe we should have them sign it the way you do on the collision damage waiver on rental cars. Hearing aid dispensers should also be required to demonstrate the T-coil switch by installing an induction loop in their office/store. Brochures should be developed that provide information on the benefits of a telecoil. Hearing aid dispensers should distribute the brochure. Thank you for your time, and I'm happy to, answer. And if you want a separate presentation on induction loops around the world, I'm happy to present that. I've presented to the U.S. Access Board on this, and that was the precipitous of the change of legislation. I'm on the PVAG committee. I'm on the Rail committee. I'm on the Taxi of Tomorrow committee. As I mentioned, the New York State committee. I was previously on the FCC's Consumer Advisory Committee. Of course, I'm not here in any of those capacities. Thank you.
Thank you. Anybody else? Public comment?
I have several comments, but I do have but not. Are we talking about the telecoil issue now, or the?
I think it would probably be helpful. I mean, if somebody else has
there are two different categories, two additional things. All right. With regard, just technically speaking, in one of Janice, instead of coupler for telecoil, it's transducer, and I'll explain that afterwards. Telecoils. In 1987, when I started my private practice, I installed a teleloop system, and it's been in effect ever since. It is not a big deal to do. It's a very advantageous thing to do. I think the telephone connectivity, when we speak in terms of training and education for the dispensing professional, be they hearing aid dispensers or audiologist dispensers, it is included in my training that these items are discussed and shown, but it isn't required that they're shown. It is required that they're discussed and counseled about it. Now, taking the consumer standpoint and the professional standpoint in mind, consumers are not always able to reflect everything that has been said to them accurately. Either one, because they don't hear it, or two, because they just don't remember it. And age is a factor. Whether you're a child, you may not understand what you've been told. If you're an adult, you also may not understand what you've been told. And if you're an aging one, you have even more trouble. And so that I know many times dispensers, all of us here, can say, "You never told me that I needed to change the battery," or "That's how the battery went in." Well, guess we do it 99 times a day. And yet we tell them about telecoils, but they don't want to hear it because they want something else. It's very hard to change the mind of a consumer who comes in with a predisposition or with ignorance as a predisposition. So you really need to, and the ignorance is not their fault, they're just not informed. So yes, it is an advantage to add telephone connectivity in all its forms. Telecoil's been around for a long time. There has been a change in telephones so that now that you can receive telecoil communication. There was a whole change in the FDA and the hearing aid industry modifying their hearing aids and their telephones because they would vibrate and you couldn't hear over the vibration. And now telephones are rated so that if you get a telephone, it has to be rated either 3 or 4, otherwise you don't have a hope in hell of hearing with the telecoil. I don't care what telecoil you put in it. So there's a lot to the technology in the hearing aid industry that has changed, and the telephone industry. Fred, my husband is on the Telephone Standards Committee. I'm on the Hearing Aid Standards Committee. We are both on the Hearing Aid Standards Committee. We are knowledgeable about this. It should be available to the consumer. I recommend something like what I put in my purchase order agreement. I have a statement that says you've been advised that you should be using binaural hearing aids in the instances where they should be. Not everybody should, but where they should be, and they must sign if they refuse to take the second hearing aid, because it's safety for them. Telecoil, you can have them sign that they've been counseled and advised. Maybe it's not appropriate that they try it, because not every hearing loss and not every person can manage the little adaptiveness. Yes, remote controls work very well, but men work very well with remotes. Women do not work as well with remotes because it's in the bottom of their pocketbook. So, you have to take the consumer counseling issues and what they bring to the table and what you can bring to their table and let their wide world open. Some people don't open their world, whatever you tell them.
You can't make people do it, but you can at least
You can bring it to the
bring
table.
It to the table.
Absolutely.
And there are going to be people who always say no. That's okay. But then they made an informed decision.
Right.
And I agree with that.
I have comments on issues pertaining to the national exam and to the traineeship, but should we want to stay on telephone communication first?
Does anybody else there have T-coil comments?
Go right ahead.
I just wanted to add that there has been research done, I think at Johns Hopkins, that shows a clinical link between the hearing loss and early onset of Alzheimer's and dementia.
Right. Oh, it absolutely.
And I think that if more dispensers and audiologists were aware of that fact, not with children, but when they counsel and advise their clients who are adults, that it might make a bit of a difference in helping them maximize their ability to hear in all settings.
I think most audiologists are aware about the Alzheimer's business and amplification. Stimulation is very important, and that's the way to get it. You have to hear it to use it and remember it.
Is there anybody else in New York City that hasn't spoken who would like to speak in regard to telecoils? Anybody in Albany want to speak to that? No. Okay. So we've covered that for the public comment. Barbara, if you want to speak to something else, and then if there's anybody else there who wants to speak to another topic, they're welcome to after you.
Okay. I'll start with the short thing on the national exam. I do think a national exam, first of all, education is important for the dispenser. The audiologists get a significant amount of education. They're required to have a doctoral degree. They have years of education. The hearing aid dispenser is required to get what is ever given to them to meet the New York State standard, and that needs work. The national exam, yes, you take a look at the state exam, but the national exam for the hearing aid dispenser, non-audiologist dispenser, I think might be a good idea. But with that in mind, the national exam for the audiologist should be recognized, and thus they would not need to take the dispensing exam. They would need to only do the ear mold impression if that's what was deemed necessary.
So they do that now.
Barbara, that's what it is now.
But no, they do that now after 5 years or 4 to 5 years of training. Whereas the hearing aid, non-audiologist hearing aid dispenser can do it in 1 year. So the audiology student, which reads into the audiology traineeship issue, the audiology student who is a student in a doctoral program who has to wait to become a hearing aid dispenser unless they take your full exam. Now they can take their audiology clinical praxis exam for the AUD after the 2nd year if they feel they've got enough under their belt knowledge. They can wait to the 4th year. They can wait to the 3rd year. But at that point, they have 2 years to be able to file and get their audiology license or their ASHA certification with the national exam and be able to practice anywhere in the state, in the nation. That's why it's a national exam. And regarding the traineeship issue, we've had trouble down here, and Dr. Freddie Jamel is here to talk about the issues. I've run into 2 issues because in teaching, I get calls at least once or twice a week from people around the state, and the traineeship, people from the New Jersey doctoral program who do clinical traineeships in New York State and live in New York State often are not getting their annual traineeship certificate. We agreed back a year and a half ago, actually in 2009 when it was first started, that the traineeship was required for the audiology students. They're supposed to every year refile. Whenever they go out on their first clinical externship, they have to have under their belt the traineeship. And that's for the year. And they have to renew it each year so that they can then go from clerkship to clerkship to clerkship and to their final residency program. Now, those people have not been getting it appropriately when they're placed in New Jersey. Dr. Jamel will talk about that. I have, in fact, encountered a student, a person who came into New York State, hired by a manufacturer. I will not say their name, the manufacturer, but they were hired. Audiologists are often hired to go and do clinical assistance in the offices to train people to use different devices and know the software and handle complicated fittings. People who are having trouble with the devices. They go from office to office. They're audiologists or hearing aid dispensers, and they need to hold a license in New York State. This person wasn't able to get one because their license came from another state. Their audiology license came from another state, and their hearing aid dispensing experience was from another state. Why? That's ridiculous.
Okay, well.
Quickly, okay, and just want to ask a quick question.
Barbara?
Yes.
Barbara,
Ed.
I have one point, well, 2 points really. One is you were talking about the students who serve their trainees, do 2 years of traineeship, or second year, I'm sorry, they did 2 years of their AUD program, and they're entitled to take the actual exam. Is that what you're saying?
They're entitled to take the national exam, yes.
Okay, so with that, I think she's suggesting that, like the audiologists who have a license as audiologists, based on our law, she's suggesting, I mean, we know that all they have to do is take the ear mold exam. So I think what she's implying, I'm guessing at this, is that if they take the national exam that audiologists take after 2 years of their clinical residency program, they should be allowed to just take the ear mold exam and become a dispenser versus an audiologist. Is that what you're saying?
I'm saying that they should be able to do it at any time they feel adequately, academically equipped and clinically equipped to take the test, yes. As long as they've had the criteria. As long as they've met the criteria.
You're saying that they should, but it's with taking the national audiology exam.
Yeah.
So that's what she's saying, which is not part of our regulation, but I don't know. It's reasonable.
Right. Because the original law was written without the audiology student in mind. It grandfathered existing people and everything else fell in the crack.
Well, we have a regulation now where they can.
Now, exactly, you do.
So what she's saying is our regulation could be expanded, which may not be a bad idea, to allow the student who takes the national exam to take the ear mold exam to become a hearing aid dispenser, not an audiologist, obviously. Does that make sense?
Yeah, I mean, we could look at it. I think it runs, counter to the current legislation, which says you have to be licensed as a thing. But, maybe part of that subcommittee that will be looking at things on a more global basis can include that as one of the things to address.
Yeah, that it might fit under that global issue.
You said something else, Barbara.
Unremarkable.
I spoke about the telephone connectivity, the national exam, and the traineeship.
Okay, so my name is Dr. Freddie Jarmel. I am the clinic director at Montclair State University, which is located in New Jersey. And we are the only doctoral program in audiology in the state of New Jersey. In the metropolitan area, there are 3 programs, one part of the CUNY system, one the Long Island Consortium, and then our program. Upwards of a quarter, and sometimes possibly more, we don't know down the line, of our students come from New York, and we have a large number of externship sites that we send our students to in New York. As part of the regulations for New York, the students are required to get a temporary certificate, a hearing aid dispensing certificate, when they do their externships. And the mechanism that was put into place to actually streamline the process was a good one, which allowed that if we had a New York State licensed dispenser on our faculty, which we do, we actually have 2, that person can then be the overseer and the supervisor for their externship placements, so that the students are only required to fill out an application one time and then can renew it on an annual basis, even though they're going semester after semester after semester to multiple different sites. And so we encouraged all of our students to, in fact, do that, fill out the application, and we had our dispensing audiologist sign off on that line. What we got back was a rejection. Our student was the first one who applied for this, was denied, and the reason that was stated on the denial letter was the business location must be a New York State hearing aid business located in the state of New York. And that I find very troublesome. Part of the requirements stated that the student must be in a nationally accredited university program that leads towards New York State licensure in audiology. And in fact, our program meets and exceeds those requirements. So we believe that this is a relatively simple fix, is just to allow our audiologists and our hearing, New York State licensed dispenser to sign off on it, regardless of where the university physically is located. The students are doing their placements in New York under the supervision, of New York State licensed audiologists. So.
You can't regulate outside New York State.
Can't regulate.
I think we're going to have to look into that because it's.
Do you leave her contact information?
Yeah. Can you leave the contact information with somebody from our office down there so that somebody can be able to get back to you?
I'm going to speak to the fact that I brought this up to Carol and Mark and to others. You have information and correspondence with regard to this for more than 6 months, and that it's not been addressed. And the students it was supposed to facilitate it. The manager, the person at the university was supposed to handle the supervision, and they could go to whatever placement and they get it once a year. That was the purpose of the whole traineeship. And we streamlined it appropriately, and it went into effect June of 12. Now, it needs to be implemented properly. Tell your people who are licensing people to approve it.
Can I say something in your defense? I hear what you're saying, and I agree with everything about the students and about our regulation. And the problem that I see for us as New York State is that the facility is not in New York State. And we can't regulate or license, I don't believe, a facility outside of New York State based on what my understanding is. Now,
you're not licensing the facility.
One way around it,
you're not licensing the university.
Imagine would be to have the students who are placed in New York State as their facility, a licensed facility by the Department of State, a New York State facility, and have their supervisor, who's in New York State, attached to that facility. But New Jersey is not New York State. And I'm very liberal about this, and I'm very happy to do anything that makes it go forward.
Ed, you're not licensing the facility. You're not licensing the facility of the university. You're licensing the student who is going to different clerkships. The whole reason it was modified was so that you didn't have to pay the fee for every single time you reapply. It takes so long to get the applications through. As you change clerkships, you have to do it 3 to 4 times a year instead of once. It's paperwork that shouldn't need to be done.
Barbara?
Yes?
Barbara, Mark indicated that he does have contact information. Whitney
Good.
said she will look at it. She will get back to the school, and you know we'll move forward on that. So
Please copy me on it.
Thank you.
I'm not going to do that.
Okay. No, I mean
I'm not
whenever.
going to do that. I'll communicate directly with the school.
School shouldn't be an issue.
Barbara, yeah.
We're not licensing the school.
We're not licensing the school.
Barbara, with all due
Yes.
respect, I need to communicate directly with the school. If the school feels like informing you about our discussions afterwards, that's fine. My
Not
contact
a
will be solely
problem,
with
not a
her.
problem.
Any more public comments in New York? Well, the room cleared out, didn't it?
Yeah.
Okay, if that's the case, then you know what? Let me ask in Albany. Fred, want to start?
That's it, yeah, whatever. Because it has a bench here. Bench.
Need a microphone? Can you hear him?
Yeah. No,
No, I need a mic for.
They can hear you, but. 5 minutes, right?
Okay. Good morning, my name is Fred Goosen. I am the Executive Director of the Hearing Healthcare Alliance of New York, which is the professional association of dispensers, dispensing audiologists, and some ENTs. And I'm also a dispensing, a registered dispenser in New York State, and have been so for 19 years. However, today I'm speaking from my Hearing Healthcare Alliance position, and the fact that in 1998, we passed a law after great consternation, years of work, and Ed and I worked together for years and couldn't get it done. We got it done in 98. And we thought that what we had put together put us in the forefront of dispensing regulations and procedures in the United States. We developed an advisory board. We had developed an advisory board for the purpose of giving the Department of State resources so they could understand what types of materials were needed, what types of instruments, what hearing aids were, what hearing loss was, where consistency was, where currency was. And we used that with the base in writing the law. However, now we find ourselves 15 years later. We find ourselves 15 years later, and we have had, yes.
New York, can you please mute? Thank you. Tedford.
Okay, thank you. We find ourselves 15 years later, and we're discovering and seeing that the exam and training programs that were put into place in 1999 have never been reviewed, and actually, in looking at them, are requiring knowledge in hearing instruments that no longer exist. Well, I think it's time, and I congratulate the board today on looking at how we are preparing people to assure them they have the minimum level of competency to dispense hearing aids to New York State's hearing impaired, and that the exam and the training program should be together to guarantee that the dispensers that we are putting in the field and they've passed the test are that. Remember, the training course that we built in 1998 was intended to be temporary, in the belief that community colleges across the state and the nation would soon be developing two-year programs. And as a matter of fact, in some of the initial drafts, the Department of State was going to first list those courses that must be included in the 60 hours for your registration. That should be taken, possibly anatomy of the ear, possibly hearing disorders, but within that 60 hours, that was the first step. That didn't happen. Secondly, we didn't get the community college programs which were supposed to have been in place in 5 years, and that did not happen either, because there are only 3 or 4 associate's degrees currently being offered in New York State in hearing instrument sciences. Most of them are in the Midwest, and 2 or 3 are also in Oregon. We haven't developed that. Well, our problem and concerns about the training course is this. that there's not enough guidance for the hearing aid dispenser who's delivering the course. There's not enough guidance. These people are professionals in dispensing hearing aids. They are not professionals in teaching. They are very, very capable of guiding the student through the hands-on portion of the test, but not the theory. And if they are a small office with only one dispenser in the office, to teach and teach and that, it severely restricts their ability to move forward by training the new student. As we said, and found, the syllabus that we have currently was developed in 1999. Secondly, we don't know where the question answers are to be found. Any developmental program, any coursework, we don't know which books are being used, we don't know which books to use, we don't know where do people go to find the information that they need in order to A, train the student, and for the student to learn what needed to be before they get to the exam. As all professionals know, we have the syllabus includes almost everything that's included in this book, which is Hearing Instrument Science and Fitting Practices. It has, if you read the table of contents, it'll read just like our syllabus. This is a book that's available. There are other books that are available. Unfortunately, we're also concerned that some of the books that might be available are for audiologists. We are not audiologists. There's a separation in the way that we both operate in terms of analyzing, interpreting the information that are given to us by the test, and we do not want to be tested outside of our scope of practice, unless, of course, the department is expanding our scope of practice. But I don't think so. So we have to be very careful of that, and I think that's one of the programs. What we're most concerned about, that the materials that are related to the course instruction should be compiled and references where they may be obtained and should include in the syllabus provided by the Department of State. Basically, to guarantee continuity in the training and the evaluation of all candidates for registration as hearing aid dispensers, and that all are being prepared for the qualifying exams in an appropriate manner and are provided with the resources that will assure they meet the standardized requirements of minimum competency in hearing aid dispensing. My problem is I get the same phone calls. Someone is hiring it, wants to bring into the practice a new person. Where do we get the information? What books are being used? Where do the questions come from? Now, this board has never been consulted about what's in the exam. When there's a question about a course, we had one marked this year that you were unable to approve, and the answer was, I didn't understand some of the terminology in there. Well, there's a room full of people here that could have explained that, and so hence I had to take 2 courses out of my conference and replace them with other ones. But this group of professionals need to be involved in the process more. That's what they're here for. The exam should also reflect the topics that are being required to be taught in regulation and ensure that the proportions, 45 hours in one topic area, 45 hours in another topic area, 5 hours in infection control. The exam, like all valid exams, should reflect that same level of study, and that if I'm only going to be studying infection control for 5 hours out of 155 hours, my exam, the exam that I must take, should reflect that relationship between the other more important courses. The question also is about validity, psychometric evaluation. Are the questions designed in such a way that they perform the task required of them, which is to validate and certify that the candidate taking that truly is understanding and answering a question that leads to minimum competency. I don't know who you use as psychometricians and when you go through these exams. I do know that at International Hearing Society, they use 2 private companies that come in from the outside to do that. They renew their questions every single year. Every single year, because every single year there are changes. And so yes, as we talked earlier about renewing or upgrading or updating, that is not every 5-year process. The Secretary must understand that is an annual process. Changes happen so fast in the last 5 years. The whole introduction of chips in the instruments, the kinds of wireless functions that they perform, that can't be done once every 4 or 5 years. It has to be done every year. And you don't deliver many tests in the state. Now I'm kind of sliding off to the other side. It's a lot of personal effort in your department to prepare 20 tests, especially to stay attuned to what's going on. Most importantly, I have nothing but anecdotal evidence about what kinds of questions are being asked, because we ask our students after they've taken the test, what's on it? And some of their eyes are rolling because they didn't know where, they didn't maybe have the right book. Now, the requirement of me as a trainer, as an instructor, is to send to the department a list of the books and materials I'm going to use. How does that work? Does the department write back say these are the wrong ones? That they're the good ones? You may be overlooking the fact that there are 5 different masking theories. Which one do you do? Matt Chartrand's, Fred Paris, which one? It's important. So again, standardization of the training program, some help, maybe something like this, train the trainer, which takes the training dispenser through step by step for the 1-year month traineeship, so that person who's actually delivering these courses will have a sense of how everybody else is doing it. How do we guarantee that every student going through the process is being trained in a way that leads to the program? I am very excited that the board is going to be involved in looking at the exams again. We are very concerned. I've been in this profession for 20 years. I have a great deal of respect for the people I work with. I know what kinds of students I had to go through, and I want to be very sure that as we go forward, that hearing aid dispensers in New York State are at the same level as the other state dispensers. After all, 39 states do use another exam. 12 of those states use also the International Hearing Society practical exam. And on that point, I would hope that if some candidates are only required to take the practical, that the New York State law and regulations be included in that provision. Dispensers are required to know what the law says. I would think that other students also should be required to know what the New York State law says. In conclusion, the major concern we have is the advisory board has been given specific statutory authority to advise the Secretary of State on the content, delivery, and evaluation of any examination required as a condition of registration. And the Secretary of State is only required to offer an examination. Not to construct it, not to write it, but to offer it. So it could be another exam. Now, Florence, I'd love to talk to you, and very much love to talk to you about the Hearing Healthcare Alliance working with you regarding ALDs, and especially working on this project that you're proposing. Great. And I'd also like very much to work with you because our spring conference in May in Saratoga, I'd love to put a program together to be delivered at that conference of at least 1 or 2 hours of instruction on those very issues. Please accept that from us. It's been a very interesting meeting, and I appreciate once again being able to address you with our issues. I'm very excited that the major issue of the exam and the training program is being addressed and looked at. And I also will make a brief statement about internet sales. Remember how much work a dispenser or a dispensing audiologist has to spend with an individual client today with programmable hearing aids. There's a wonderful sham by United Health Systems that says you can get $300 to $700 hearing aids. Well, let me tell you how that works. They come to me and get an exam, an audiogram, I give it to them, they mail it to California with a check. California mails them a pair of hearing aids. They put it on. They fill out a checklist, what they like and don't like. They put it back in the box, mail it back to Florida. Florida changes the hearing aid. They put it back in the box, mails it back to New York State. Person takes the hearing aids out, puts them on their head, fills out another checklist, puts it back in the box, sends it back to Florida. There are no dispensers or dispensing audiologists involved. We are not free. If there are online programs that actually are represented by dispensers or dispensing audiologists, but the key that we have and the concern that we have is there must be a professional relationship with a hearing impaired person in order to get the most help out of hearing amplification. To go forward, just think of that. Overall, thank you again. Thank you, and thank you to the department for your work with us. I know we send you a bunch of stuff. We'll get back some of it back pretty quickly, and I do appreciate that. And thanks for the opportunity to speak.
Anybody else from Albany? Public want to speak? At this point, can I, final comment?
Can I ask a question? Sorry.
Wait a minute. Who's, I don't know who's talking.
It's Kruger.
Barbara Kruger, question?
Well, Barbara, you know what, if it's about the comments, I mean, they're comments.
No, it's not. It's about a different issue.
You know what? I would say the public comment period is over at this point. I don't want to cut you off, but we've kind of run long on the whole thing. So I'd like to have the public comment period.
It pertains to ENT and dispensing and.
Maybe you can shoot us an email or something.
I'll be glad to.
Okay, thank you. Can I get a motion at this point to adjourn? Ed, second? Yeah, thank you. Everybody in favor of adjourning?
Email me?
Yes,
Send me your email. Thank you.
Write your email.
Okay.
I'll send you everything.
Thank you.